Hello, I don't quite know whether to say good afternoon, good morning, or good evening to you because I don't necessarily know when you will be watching this video. But this short video is the first of two that I am recording ahead of the Modern Law Review seminar on the subject of emerging technologies, personality laws, and the dead. I'm Dr. Jonathan Brown, and I'll be contributing to session 1 concerning the reluctance to protect personality and privacy of the dead, as well as session 4 concerning directly the emerging laws which might be used to afford protection of privacy interests of dead people. Now, in respect of this video, I will be addressing what my position is in respect of session 1. That being that I would hold that there is a general reluctance to protect the interests, personality interests and privacy interests of dead persons, certainly within Scots law, because there is, more generally speaking, a reluctance to protect personality interests simply and plainly, even in respect of living persons. And I would not presume to comment on the position in any other jurisdiction other than that which I'm most familiar with, that being Scotland. But within Scotland, we've found ourselves in a rather curious position because although the Roman, and indeed the Roman Dutch, actio injuriarum, or action for affront, or the action to repair, dignitary interests which have been affronted through contumelious conduct, although this actio injuriarum was received into Scots law during the institutional period of our legal system, that is, at the foundational point of our legal system, which remains uncodified and dependent in part on institutional writers to this day. Although we've received this actio injuriarum, we have neglected our institutional connection to the action, and as a result, although one might expect the law of Scotland to look rather like the law of South Africa, in which there is a clear bifurcation between Aquilian liability, according to the Actio Legis Aquilii, or the Actio de Damno Dato, and the concept of liability for affront based on injuria. Although you might expect Scots law to divide neatly in that way, at present, although this division can be detected in the sources, it's not manifestly apparent that the law does divide this way. It's not manifestly apparent that things are quite so neat. And indeed, the idea of culpa or fault as being the primary driver of liability in the Scots law of delict has taken hold, and although Scots academics, commentators and judges are getting away from the idea that all delict is predicated on the occurrence of fault, the idea that for a claim to be actionable there must be some kind of loss, patrimonial loss, or loss, or something capable of being comprehended in patrimonial terms, that is still quite entrenched in the minds of some practitioners. With the net effect, then, that protection of personality interests, such as any dignitary or non-patrimonial interest, is altogether more difficult than it ought to be, which is quite plainly demonstrated by the recent case of BC against the Chief Constable in 2019, the Chief Constable of Police Scotland, that is. Now, in BC, at first instance, Lord Bannatyne held that there is indeed a nascent recognition of a common law right of privacy in the case law in Scotland. But on appeal, although this point stood, Lady Dorian in the Inner House expressed regret that this was not a live issue before her, since there was some potential for scepticism about the veracity of Lord Bannatyne's claim. Lord Bannatyne's claim, of course, rested primarily on the recognition of the idea of privacy which is developed in English law out of cases such as Campbell against MGM Limited. Now, it's quite bizarre to find in Scotland the Scottish courts making use of English sources to develop a right to privacy, given especially that cases like Wainwright against the Home Office and so on indicate that there has been a structural hostility towards recognition of high-level principles such as privacy within English law. There is no reason for there to be such hostility to the concept of privacy in Scots law. The Scots law of delict is structurally entirely different from the Anglo-American law of tort, and there is, it's far easier, in fact, to establish liability under a delictual regime than it is in the context of the law of tort, where the forms of action continue to exert an influence. So with this in mind then, I'm coming to this panel with the perception that it is difficult to protect and preserve the interests of the dead in this jurisdiction, certainly, because at present it is actually really quite difficult to protect even the personality interests of the living. So with this in mind, the second panel to which I'll be contributing, the second video that I'll make, will be an attempt to explain how Scotland might, in spite of the position which it finds itself in at present, nonetheless be able to afford some kind of mechanism to allow certain persons, natural legal persons, to vindicate the interests of deceased persons within the confines of the Scots legal system. Thank you.